Cool. All right. Good afternoon. Thank you for your patience, everyone. We were having technical difficulties. Hopefully, we're not still. Welcome to Economic Matters for our 2:30 bill hearing. We have about 13 bills on the docket, and we're going to start with Madam Chair. Chair Beidel with Senate Bill 594. Do you have a panel, Madam Chair?
Physical chair. I'm your chair.
Yeah. Do you have a panel with you, Madam Chair?
I don't know why it's signed in.
Okay.
Members of Economic Matters, for the record, I'm Pam Beidel, representing District 32, Anne Arundel County. Thank you for the opportunity to present Senate Bill 594, Cannabis Advertising Alterations. It passed the Senate 30-11 as amended. Senate Bill 594 endeavors to balance public health safeguards while acknowledging the struggles both newly awarded social equity licenses and operating cannabis licenses have competing in the market, saturated by unlicensed and illegal sales of intoxicating THC products, whether hemp or cannabis derived. Unlicensed businesses do not follow the restrictions on advertising that a licensed business must follow. They do not charge or remit the higher cannabis sales and use tax in the state that is imposed on cannabis sold in the regulated market, and may be more likely to target and sell intoxicating THC products to minors. Senate Bill 594 balances these policy interests through the careful alteration of existing restrictions on advertising for cannabis licenses in the state. Senate Bill 594 expands the amount of signage that a licensed standard dispensary is authorized. And while it expands it, it also limits it. There's been some signage that's come up in stores, and you see one in Annapolis on West Street that has this huge sign because the inspector allowed it. So this bill actually spells out how many square inches of sign you can have. Now, we're asking the Cannabis Administration, if you have a sign that says deliveries in the back or parking in the back, is that going to be part of the square inches that we delineate in the signage? And apparently it is. So they're being very strict about it. But they were not strict when Gold Leaf put their sign up that's huge. So we're trying to we're not really expanding the signage, but being more specific. But by changing the signage rules, it will allow someone that is a woman-owned business, a minority business, a black-owned business, a woman-owned business, they're going to be able to state things like that they can't now. So you can put up your cannabis sign and say, you know, this is a woman-owned business, this is a veteran-owned business. You can't do that now. So that's the kind of things that the bill is addressing. Currently, cannabis licenses may only place exterior signage on the premises of the business for the limited purpose of identifying the business to the public. Under the bill, a licensed standard dispenser may also place exterior signage within the sign limits established to provide complete contact information. Who wants to run a business that can't have their contact information available? And provide public health resources that can be used if an adverse cannabis event occurs. The Senate Bill 594 also creates predictability in advertising for cannabis licensees and ensures that the audience composition of cannabis advertisement meets the requirement of at least 85% of the audience must be over age of 21, by establishing a statutory method for determining whether an advertisement or a proposed advertisement meets the audience composition and threshold, requiring that the Cannabis Administration establish regulations by January 1, 2027, to accept an attestation regarding event sponsorship. We also, in the amendment, took out the definition of therapeutic cannabis so that the Cannabis Administration can create that definition, and they've committed to us that they will do that in the near future. News media articles, interviews, and other editorial content over which a licensee has no control are excluded from the advertising requirements, and I respectfully request a favorable report for Senate Bill 594.
Thank you, Madam Chair. We'll start with questions with Delegate Pippy.
Thank you.
Thank you, Madam Chair. Madam Chair, good to see you. I just had a couple questions. So on the reprint, I'm assuming the reprint is what was passed out of the Senate?
Yes, has the amendment.
So page 2, line 21 and 25, it talks about marketing to children. And it looks like they bracketed language out of, so right now, the original law said you were not allowed to directly or indirectly target individuals under 21, but this bill would bracket out indirectly. And then on 25, the original law says targets or is attractive to minors, but this bill would bracket out is attractive. And so I guess the question is, does this make, I mean, are we marketing to minors?
Not directly, but I'll give you, this is one of the examples. I had a number of examples come to me. So we had one of the retail dispensaries in the interior of his building put up Christmas decorations. And an inspector came in and was going to fine him and required that he take down the Christmas decorations because children walking by the store would indirectly be influenced by those Christmas decorations. That's an example of indirectly.
I understand. I mean, look, I grew up in the 80s when there was like Joe Camel and, you know, Camel-looking candy cigarettes and other things of that nature. I survived. But would you be open to possibly keeping those things in there?
Keeping the indirectly in?
Yeah,
No,
indirectly and attractive too?
That was an important part of why we brought the bill, because they were being overly enforced on indirectly. I have a lot of examples. I can share more with you. That was just one that was, I think, the most egregious.
Yeah. I'll tell you what, if you and I could meet offline, talk about your bill, I'd love that.
Okay, thank you.
Perfect. Thank you, Madam Speaker.
Delegate Amprey?
Madam Chair, thank you so much for coming and bringing this bill. I love the discussion around indirect. I'd like to join that conversation there, Pippi, with me. You have that conversation. But I guess my question is around the signage, just the size of the signage, just trying to understand what's allowed in that sign. I know you mentioned earlier, like, people want to be able to put like Black-owned or veteran-owned. Are they also allowed to put like the logo or name of their brand in that sign, or is it just that you can have that signage for that type of? I just want to understand the distinction.
No, they can have their logo on their signage. They're still limited to how much signage they can have.
Okay.
But, you know, 900 square inches for exterior and 1,200 square inches total for all exterior signage.
Got it. Okay. I just want to understand what could be on the sign as currently drafted. Thank you. That's all. I just wanted that clarification.
If I can just share another example.
Yeah, go for it.
I have one of my business owners that's very philanthropic and does a lot to support the hospice and the hospital. So he was contributing $25,000 to a hospital golf tournament. And because of the indirect advertising to children. Now, this was a $2,500 for a foursome, so we're not talking about very many children would be there, but they wouldn't let him use his logo in his advertising, and he was a $25,000 sponsor.
No, look, I think some of the stuff is very onerous, and we should try to make it, you know, fair and balanced. So I appreciate the bill. And
so, Senator, the other thing is we're seeing like there's 182 businesses that have been authorized to become cannabis retailers, growers, micro growers. Would you want to start a new business in a competitive market without being able to advertise? Thank you, Delegate Amprey. I appreciate it. Thank you.
He loves that, Madam Chair. You just elevated him to senator as well. Well, Pippi called me speaker, so. All right. Madam Chair, there's no further questions for you. Thank you for your testimony.
Thank you very much.
I'm going to call on Mark Brody, Ashley Bagwell, Bill Frick, Joe Bryce, and Obi Chinamere.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of the Maryland Dispensary Association in very strong support of Senate Bill 594. Madam Chair, Mr. Bryce is across the street, so he won't be here. He did allow me to say for the committee that the association he represents, representing the growers and processors, are in full support and aligned with our position. Earlier this year, we were in this committee supporting House Bill 1519, which is Delegate Amprey's bill, which included, among other things, a lot of the same provisions included in Senate Bill 594. As we stated then when we testified, Maryland has some of the strictest cannabis laws related to advertising in the country, and we believe that this bill doesn't weaken those laws, nor does it expand to allow more advertising. Rather, this bill brings some clarity to the statute already so that licensees can continue the minimal form of advertising that they've been doing for the past few years. I did want to raise for the committee's awareness a point that Chair Beidel made when she testified. She flagged language related to maximum caps and on advertising and specifically on signs. The language, we think, inadvertently includes operational type signs. So if you have signs on your property that says additional parking in the rear, that would count towards these max caps. And so we would request language from this committee that would possibly exempt operational type signs. And with that, Madam Chair, we will urge a favorable vote on Senate Bill 594. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Obi Chinamera on behalf of Curio Wellness and Story of Maryland. First, I want to thank Chair Beidel for her support in this issue and also your committee support. You guys have worked hard on cannabis over the last couple of years, and this industry is continuing to modernize, and all we're asking for is that the laws on the books continue to modernize as well as we seem to learn and realize things are happening. You know, really quickly, the big thing for us is making sure that we thank the MCA for their work on this issue, thank the chair for their issue, and at the end of the day, I think the big thing for us is that we want to make sure that this industry continues to grow. The legislature has kind of seen a desire to see this industry grow, and you guys voted for it and put it on the ballot, and then the voters voted for it. So the big thing is that this is a legal industry. There's a lot of illegal operators who don't have to follow these laws, which I think we've all been in agreement about making sure that the legal industry is taken care of and eliminated. But at the same time, allowing to make sure that the members who are participating in this program legally and are also paying dues and taxes and fines or fees to the organization, to the state, get the opportunity to kind of keep doing that and grow. But the main thing is that the fines that are kind of being limited or being put onto these organizations can be lowered and allow us to kind of grow peacefully. So thank you.
Madam Chair, Madam Vice Chair, members of the committee. Bill Frick, I represent District Cannabis of Hagerstown. I want to express our deep gratitude to Chair Beidel for this bill, for her committee and this committee for the work on these issues. I would be inclined, Madam Chair, just to offer a hearty me too to the testimony of our panelists. We are in strong agreement and great appreciation for the work that they have done on this. But I do want to flag an additional issue, Madam Chair, that's come up since this bill was actually introduced. In February, my client received a letter of noncompliance and a cease and desist notice relating to a packaging on a series of products. The products in question had images of waterfalls, deserts, palm trees, mountains, an airplane, and a beach. No cartoons, no images of food, nothing that appeals to children, absolutely nothing that violates the language of the Cannabis Reform Act. Instead, the MCA sent us this letter of noncompliance because they said it violated regulations. The packaging must be plain. That's a term in the MCA's packaging regulations in a section dealing with childproof and tamper-evident packaging. As asserted by this notice, however, members of the committee, they can punish any licensee at any time for any packaging that has any design or any image. We don't believe that's consistent with the law, but as of today, that is the MCA's assertion. The industry can't operate this way, Madam Chair. We ask you move forward with this bill. We ask you also address this new problem. I've given Delegate Amprey's office some language that could do so. We thank you, the General Assembly, and specifically this committee, for your efforts to support a healthy, thriving, equitable, and successful legal cannabis market in Maryland, and we urge a favorable report.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Mark Brody. I have a standard dispensary license and the social equity licensee group. I'm here also representing the Maryland Coalition for Cannabis Equity in favor of this bill. I'm not open yet, but like many people in our cohort, we are working really hard, investing time, energy, resources into getting open, into building something off of this opportunity that the legislature has provided for us for all the right reasons. And we really appreciate all the hard work Senator Bidel, MCA, OSC, everyone has done for us. I think really what we're asking most is that any legislation that is considered, you think about the downstream impacts that it could have on the social equity group. I know that the state has spent a lot of money and resources into getting us to where we are today, and we need to think about keeping this sustainable for this group of licensees, not just getting open, but also being sustainable throughout the life of the business. Otherwise, it would be a shame if folks end up not being able to open and be successful. We support 594 as amended by the Senate. It moves Maryland in the right direction on advertising, and we appreciate that this committee is considering it. But many of us are still working towards becoming operational, and the decision that this committee makes on this bill and others are very important to us. Reducing the social equity control cap from 65% to 51% would open the door for outside investment, so we would ask that folks to consider those amendments. It would maintain control, but it would open up doors for capital access, which is a huge reason why a large majority, 90% or more of us are not open. At the same time, we would ask this committee to resist any amendments that would increase the existing cap on dispensary ownership or modify the existing ownership moratorium without first considering the impact on social equity licensees. Thank you.
I don't see any questions for this panel. Thank you very much for your testimony this afternoon. We now have someone favorable with amendment, Selena Raleigh from MCA.
Good afternoon, everyone. My name is Selena Raleigh, Deputy Chief of Legislative Affairs. I'm joined by our Director, Ms. Tabitha Robinson. And we are really appreciative to Chair Bidel for her work and effort on refining and clarifying Maryland's cannabis advertising framework. This bill does provide the administration with additional flexibility in advertising enforcement, which we are grateful for. In addition to supporting this work, MCA recommends retaining the phrase "or is attractive to," which was struck from page 2, line 25. We are also open to working with the committee to find alternative methods of preserving these youth protection standards. We do not want to delay the progress of this bill. With this amendment, the administration supports the bill's broader goals, and for these reasons, the administration respectfully requests the adoption of the amendment and a favorable report. Thank you, and we're here to answer any questions.
Not for her. Go ahead. Now it is, but
Okay, thank you. I'm sorry. I guess my question is, so I'm just trying to, I'm looking at an opposition letter from the council, the Cannabis Public Health Advisory Council. Have you seen or heard what they're, do you agree with any of that? What they're saying?
Yeah, so I believe we did review their testimony. I think they had also requested retaining the "or is attractive to" among other things. So we agree with them on retaining that particular piece of stricken language, but otherwise we are favorable on the bill.
Okay, all right, thank you.
Thank you, Madam Chair. I guess the terms and the reason they're asked to be removed is they're very subjective. Do you guys have another definition that you'd like to be put in place of is attractive to or indirectly? Do you have a suggestion?
Sure. We are committed to working with Chair Bidle as a sponsor of this bill, as well as with industry, to find language that allows us to further protect children from exposure to such advertisements. One of the things that we observe oftentimes is licensees may intend to target adults. For example, there might be a Friday night event, a beer event, adults only, 21 plus and over, and the advertisement is present at that event, no problem. Saturday morning, however, there's a Bugs Bunny event, and the same advertising is still up there. We need the enforcement authority to be able to hold licensees liable when they're not careful, right? When there are some sort of negligence. And so our goal with keeping the current language is to cover us in those instances rather than having to assume intent. It's very difficult to prove intent. And our understanding is that the target language here is a language that leads us to assume intent. So we are open to finding other mechanisms, other language that can help us to achieve that goal.
So you're actively working with the senator for that language?
Yes, we are.
You are. And you'll get that to us? Because I'm seeing that maybe you're not.
I see. We will continue to work with.
Okay, thank you.
Thank you, Madam Chair. So just a couple questions. Do you think we should be marketing cannabis to minors? Anyone can answer that.
No.
All right. So do you think if that language in the bill as it came over stays, the indirectly or attractive, like would that potentially lead to marketing to minors?
Yes, it can.
Okay. Did you see the letter of opposition from MedCai?
I did not. No.
No, I did not.
Okay, so I think the letter of opposition from MedCai raised that same issue. There's a few other health organizations in Maryland that, Maryland Public Health Association, same opposition for those same reasons. So just to be clear, your position is that that language needs to come out to be supported. The language that was struck in the bill about.
Would need to stay. That is
You
our.
need to stay. I'm sorry. The brackets need to come out.
Yes, the brackets would
I
come
got
out,
it.
yes.
Okay. All right. I just want to make sure I clarify that. Thank you, Madam Chair.
Thank you, Madam Chair, and thank you all for being here, and thank you all for your willingness to work towards finding a solution to ensure that we can have a viable advertising mechanism for our cannabis industry here. I just want to, I guess maybe I think the conversation should not revolve around what the words are, but the reality of like, what does it look like? In the sense of like, what does indirect look like? I'm just, because I think we got an example of Christmas lights, but I guess the position from you all, like, can you give me an example of what an indirect versus direct looks like for advertising? I think the words here just don't suffice for us trying to figure out, just
I'll
what, give us
let
an
Tabitha
example.
respond, but just real quick, Delegate, just to clarify, we did not include in this testimony that we wanted to keep the word indirectly.
Okay.
We just wanted to keep in or is attractive to, but
Okay.
I'll pass it over.
Or I guess, give me an example of what makes something attractive. Like, I just want to get an idea of how you all operate in that, with that word.
Sure. I can give you some examples of attractive too. Do you recall Lisa Frank from the 80s and the 90s?
Oh.
Okay, not a cartoon, right? But heavily marketed towards children. Santa, for example, not a cartoon, heavily marketed towards children. Santa would be an example of something that the agency might consider attractive to children. It's not exclusive to children, right? But it is attractive to children.
Okay. Yeah, I see those. It's just hard sometimes because, I always use the example of the Geico lizard, right? They're selling insurance. My 5-year-old is not trying to buy no insurance, but me and my wife have to, right? But they use a cartoon lizard light. So it's just this weird, murky world of how we determine what is considered attractive to a child. My kids love, she loves like construction sites. She thinks like, my nephews like race cars, right? Adults like race cars. So it's like this weird world of like, what does it mean? So I thank you for that. Thank you for that. So, but I just want to get more on the record so we can just discuss, and I'm looking forward to more discussions offline. But it's just one of those hard things to determine. But I appreciate you all's statements.
And we agree, Delegate Embry, we agree that this is not easy work, that, this has been an ongoing conversation since the rollout of adult use in 2023 and even prior when the industry was medical only. Again, we remain committed to trying to find a happy medium ground. I think this is something that every state struggles with. So I just want to emphasize this is not a uniquely Maryland issue. We want to make sure that our licensees are able to market to their customers, are able to get their brand name out there and conduct their business, right? Understanding that cannabis, however, is not like every other business because of the federal illegality. And so we as an agency who we're tasked with the responsibility of enforcing, we will do what the General Assembly directs us to do.
Thank you, Madam Chair. I also do have some youth protection question. With the removal of indirect targeting language, how will the administration continue to ensure strong protections for minors?
Sorry, with the removal of indirect?
Targeting language.
Yes. It's for that reason exactly that we're hoping to keep is attractive to, or a phrase that does similar work.
Then what metrics, do you guys have any metrics or indicators you will use to monitor youth exposure to cannabis advertising under this new framework?
We'll be looking at the designs of the advertising. This bill also creates a requirement around audience composition. So at events, for example, proof that adults are present at those events, and we'll be looking at such data.
And the last question, do you anticipate any challenge in enforcing the signage provision at the local level?
At the local level from the counties?
Yes.
No, we do not. We also have not had any lawsuits on advertising thus far. And so even though it is in its current form, it does have a lot of restrictions. We've not seen legal challenges nor local challenges at the county level.
Thank you.
Thank you. Apologize. Follow-up question. So you brought up other states. I mean, do other states have language that's suitable or no?
You want to take that?
Off the top of my head, I don't, but I think there's going to be a conversation or two after this hearing, so happy to come prepared to that.
Okay, thank you.
Seeing no further questions, thank you very much for your testimony this afternoon, ladies. We'll now move on to the opposition. We have Stephen McKinney and George Townsend.
Madam Chair, Committee, my name is Stephen McKechnie. I am here on behalf of the Public Health Law Clinic for the University of Maryland Carey School of Law, and I am here today in opposition of Senate Bill 594 because it unnecessarily risks Maryland's minors and disproportionately harms already overburdened communities. It risks Maryland's minors by repealing the current advertising restrictions, permitting the indirect targeting of minors and usage of elements in advertisements which can be found attractive to minors. Cannabis usage in adolescents has been linked to conditions such as anxiety, depression, neurocognitive decline in adulthood, and worsened academic success. Studies show that exposure to advertisements can increase the likelihood of cannabis usage. Maryland recognized this and put protections in place in 2023 in areas such as advertising, product design, and labeling, all which function to reduce the appeal of cannabis to those under the age of 21. This bill would undo that work. Maryland currently sits among 27 other states who have provisions protecting minors from being indirectly targeted by cannabis advertisements. The risk of cannabis advertising exposure would also not affect all minors equally. Research shows that tobacco, alcohol, and cannabis retailers and advertising, including youth-oriented advertising, is unevenly concentrated in communities with higher proportions of racial minorities and lower income levels. In Maryland, nearly 48% of licensed tobacco retailers are located in Baltimore City, Baltimore County, and Prince George's County. Higher retail density increases exposure to advertisements, which in turn increases initiation, as recognized by the Surgeon General. Cannabis retailing mirrors this trend, with nearly 61% of cannabis retailers being located in Anne Arundel County, Baltimore City, Baltimore County, Montgomery County, and Prince George's County, all of which are communities with increasing minority populations. The issue is not only whether cannabis advertising harms youth, but which youth will be harmed the most. Senate Bill 594 would cause Maryland to leave this majority of states who recognize the critical importance of protecting minors from unnecessary cannabis exposure, especially in these already vulnerable communities. Thank you.
Madam Chair, Madam Vice Chair, and committee members, good afternoon. My name is George Townsend. I'm an attorney at the Legal Resource Center for Public Health Policy. I'm here to testify in opposition to Senate Bill 594. Although, to be clear, our opposition to this bill is limited to the two sets of brackets that we've discussed earlier. The sets of brackets that would remove the phrase "in or indirectly" from our existing cannabis advertising laws, and the pair that would remove "or is attractive to." In our written testimony and in previous testimony we've given for an earlier bill in this committee, we spoke to the public health harms to youth that we believe would result from the removal of this language. But I would like to speak briefly this afternoon to the issue of clarity in our advertising laws. We believe clarity is important and that clear guidelines and clear standards are beneficial to everyone. When we're considering this bill, I want to consider the language around directly or indirectly targeting underage individuals. Currently, if the MCA is considering an advertisement, they only have to consider whether that advertisement targets underage individuals, because both direct and indirect targeting are currently prohibited. This bill would take out the phrase "or indirectly," so indirectly targeting underage individuals would become permitted, while directly targeting underage individuals would remain illegal. However, this bill and other sections of Maryland law don't define what the distinction between those two terms is, which is a question we've seen raised in this hearing already. What specific qualities of an advertisement make it directly targeted at underage individuals? And on the other hand, what specific qualities of an advertisement would make it indirectly targeted? There's no clear explanation in this bill. There's no clear explanation elsewhere in Maryland law. And that distinction would be left to regulators to determine. And there's no way to ensure that their understanding of that distinction matches what this committee intends. For this reason, we respectfully request an unfavorable report or that the bill be amended to leave those code sections as they are currently written. Thank you so much.
Thank you. We'll begin with Delegate Roberts.
Thank you, Madam Chair. You're the lawyer, right? You're not a lawyer, correct? Okay, so to the lawyer.
I'm a lawyer, he's a law student.
Yes, so you said you've worked in public policy.
Public health policy, yes.
Public health policy. Yes. Have you worked within, what other policy areas have you worked in dealing with, product that shouldn't be marketed to children?
Yes, so the Legal Resource Center for Public Health Policy covers a variety of issues. I work specifically on the cannabis team, and since I started this position in 2024, I've been looking at issues related to cannabis advertising, cannabis packaging, which is dealt with in a separate area of law, but has similar concerns as well.
I think I'm specifically relating, specifically related to health, public health.
Yes.
I'm not interested in packaging. I'm talking about the advertising.
Yes, when we think about both advertising and packaging, we're thinking about the impact they have on children and the likelihood of children consuming those products and being affected by them.
Okay, have you worked on other products outside of cannabis?
I specifically work on cannabis. There are other members of my team who work on tobacco.
Okay, here's what I'm trying to get at.
Yes.
Do you have any suggestions for appropriate language or definitions for indirect versus direct?
I will say in the context of tobacco, a lot of the rules that apply to tobacco manufacturers and tobacco companies are governed by the Master Settlement Agreement. And specifically, the language in that agreement about youth advertising is that it prohibits direct or indirect targeting of youth. So it's the exact same language in that document as well.
But do they specify, does that specify what those terms mean?
Not to my knowledge, no.
Okay, so we don't have anything to reference.
I have not been able to find any legal authority distinguishing between those two terms.
Okay, all right, thank you.
Thank you.
Seeing no further questions, thank you, gentlemen, for your testimony this afternoon. Seeing no further witnesses, that concludes the bill hearing on Senate Bill 594. We'll now move on to Senate Bill 168. Senator Watson.
Good afternoon, Madam Chair, colleagues. Good to see you guys. This is going to be quick. I have with me Ms. Jackie Cooper from the Maryland Blockchain Association, just in case you have some technical questions. This is the blockchain real property title bill, which we've turned into a study to evaluate the use of blockchain technology for securing real property and leases. What the Senate decided to do was to conform to the House version, which passed through this chamber. And that's pretty much it, unless you want me to go through it all over again.
All right, there really are no questions, Senator Watson.
Thank you so much.
And no other further witnesses, so that concludes the bill hearing on Senate Bill 168.
All right.
All righty then.
Thank you.
Senator McKay, Senate Bill 747.
Thank you, Madam Chair. Thank you, committee. Senator McKay present Senate Bill 747. This is a cross file for House Bill 469. Requires condominium owners and residential-only condominiums to maintain property and insurance policy in their unit. The bill, as amended, has two little changes, or not changes. So it takes it from 10 to 25,000 in the minimum. In concerns or opposition, my understanding State Farm, which is the largest that carries these insurers, asked for the implementation to be put out 1 year so it'll take effect in 2027. With that, I'll answer any questions you may have. It's in the same posture as the bill you have already heard. Thank you, Madam Chair.
Seeing no questions, Senator McKay, and no further witnesses, that concludes the bill hearing on Senate Bill 747. Thank you. Is Senator Hayes here or Representative? Okay, Senate Bill 814.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the Economic Matters Committee. For the record, my name is George Reith, the Legislative Director for Senator Antonio Hayes, and I'm here today to present Senate Bill 814. Senate Bill 814 is a critical consumer protection measure. It protects Maryland homeowners from long-term restrictive service agreements tied to their property by defunct companies that are no longer legally authorized to operate in the state of Maryland. Prior to recent legislative fixes in June 2023, certain residential service providers locked homeowners into aggressive long-term maintenance or real estate agreements. These predatory agreements were often explicitly designed to run with the land, meaning they attempt to bind future buyers and create restrictive liens, encumbrances, or security interests on the property itself. Today, several of these service providers have forfeited their right to do business in Maryland. However, because their agreements are still recorded, these ghost companies continue to cloud property titles, creating legal nightmares for everyday Marylanders trying to sell or refinance their homes. This bill applies only to agreements signed before June 1st, 2023, by providers that are defunct and are not in good standing with the State Department of Assessments and Taxation as of June 1st, 2026. It dictates that these specific agreements cannot be effective for more than 2 years, cannot bind subsequent bona fide purchases, and cannot create a lien on the property. Any legacy agreement violating these parameters by a defunct company is rendered legally void and unenforceable. If a voided agreement has been recorded, Senate Bill 814 grants the homeowner a private right of action. They could go to the circuit court to clear the lien and seek compensatory damages, plus reasonable attorney fees. The fiscal and policy note confirms the bill will not materially affect state or local government operations or finances. It removes unnecessary legal barriers and financial traps for constituents and clears up the real estate market by untangling titles from companies that no longer exist. SB 814 is a straightforward, common sense cleanup bill that provides property rights and stops defunct businesses from holding Maryland homes hostage. For these reasons, Senator Hayes and myself respectfully request a favorable report on Senate Bill 814.
Thank you for your testimony. I have no questions for you.
Great.
We now have Lisa May from the Realtors. Favorable?
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Lisa May with Maryland Realtors. I don't have too much to add. There are approximately 1,000 of these agreements that exist today in Maryland, and they are starting to pop up in real estate transactions. Not just sales, but also financing and refinancing. And so if we can grant the protection to those property owners that we have granted to all other Marylanders through the 2023 legislation, we think that we should, and we ask for your favorable report.
Seeing no questions for you, Lisa, that would conclude the no further witnesses. That would conclude the bill hearing on Senate Bill 814. We'll now move on to Senate Bill 274. Senator Sidnor. Is there a representative, or is he here? Okay. Okay. We're going to skip to Senate Bill 12. Senator West.
Thank you, Madam Chair. It's a pleasure to be here. I believe this is my final bill hearing of my career. So, and the premise of the bill, thank you for your sympathy. The premise of the bill is very simple. I think you've heard the crossfire, and so it gets really, really hot in Maryland in the summertime, and living without air conditioning in such conditions can actually be dangerous. This bill presumes that a rented residence without air conditioning should be just as unacceptable as a rental without heat or water or indoor plumbing. Given the extreme summer heat in Maryland, our citizens who live in rentals should be provided with decent air conditioning. So this bill would require residential rental units in newly built large multifamily apartment buildings to have air conditioning sufficient to cool the apartments down to at least 80 degrees. This would also extend to existing apartment buildings that undergo the complete replacement or substantial upgrading of their electrical systems or their heating systems. In other words, if a landlord's going to spend a lot of money upgrading an existing building, the installation of air conditioning should be a part of the project. Last year, an early version of this bill was introduced by Delegate Lehman in the House and passed here overwhelmingly, but it was opposed by various organizations representing landlords. Their opposition was not based upon the basic thrust of the bill, but was based upon the fact the bill required that Maryland adopt standards promulgated by a national organization. This year, that requirement has been deleted from the bill. Instead, the bill merely evokes the 80-degree requirement, something that's easily measurable with the standard thermometer. Also, last year, the city of Baltimore was concerned that the bill would apply to a number of very old, city-owned public housing structures with electrical systems not capable of accommodating building-wide air conditioning. Language in the original version of this bill added an exemption for those structures. But the final version of this bill, as amended by the Senate, does include those structures and subjects them to the same requirement as the bill applies to all other structures, namely if there's a fundamental reworking of the bill, substantial reinstallation of the building, then the air conditioning should be added. So now there are a couple of amendments that were added to the bill in the Senate, which I should discuss. There's a controversial amendment which preempts inconsistent county local laws. That was added in the Senate. I gather that I've seen some opposition testimony in this body to that amendment. They like the rest of the bill, but they would like that amendment taken out of the bill. So I leave that to the good decision of this body as to what you want to do with it. Also, the Senate passed the bill with one additional amendment. That amendment stipulates that the bill will only apply to residential units with 10 or more individual dwellings. So we're trying to make sure that big old houses, which were subdivided into apartments, aren't inadvertently swept up into this bill. So we're trying to exclude those. With that, I would point out the bill has no fiscal note and just conclude by saying that in this day and age, our citizens, whatever their income class, should be able to live in relative comfort during those summer heat waves and not bake and sweat in intolerable heat. With that, I appreciate the committee's consideration of the bill. Happy to answer any questions.
I don't see any questions for you, Senator West. Thank you. Oh, you
there's
always
one.
push it when I'm saying there's no questions.
Rather than...
Delegate Bandari also always has to be contrary.
Yeah, thank you. Rather than the question, I would like to just thank you, Senator, for your lifetime of your service, as this may be the final bill of your remarkable career. I had a pleasure working together when I was very brand new. I just want to express my deep gratitude for everything you have done.
That wasn't contrary at all, and I appreciate the comment. Thank you.
Seeing no further questions, Senator West, thank you very much for your service. That concludes the bill hearing on Senate Bill 12. I do not see Senator Sidnor. Did Senator Augustine leave? Okay, so we're going to skip to Senate Bill 389, Maryland Land Use TOD Bill. Welcome, Safe.
Thank you, Madam Chair, Madam Vice Chair, and members of ECM Committee. It's a pleasure to be here again. For the record, I'm Safe Ratul. I'm the Deputy Legislative Officer for Governor Moore, and I'm here to support SB 389, Maryland Transit and Housing Opportunity Act. So first, I want to thank the Chair, the Vice Chair, Subcommittee Chair Bandari, and Committee Counsel Ben Voigt for their ongoing work on this legislation. I'll keep this very brief. The legislation aims to address zoning and financing issues related to successful TOD developments in targeted rail stations in Maryland. Currently, SB 389 and the House Bill 894, which the House passed, are in different postures. We are actively working with both the House and the Senate to resolve the differences in the bill. The core intent of offering a comprehensive strategy around addressing zoning constraints and financial challenges around broader TOD development remains intact in both versions of this legislation. With that, I thank you for your time and appreciate your consideration.
Thank you, Safe. I do not see any questions for you. Thank you for your testimony this afternoon. I do have, is Joe McAndrew here from MDOT?
He will not be here.
He will not be here. Okay. Seeing no further witnesses, that concludes the bill hearing on Senate Bill 389. Senator Love, Senate Bill 335.
Good afternoon, Madam Chair, Madam Vice Chair. That is super fun to say sitting here. I just have to say that. Members of the Economic Matters Committee, Senator Sarah Love from Montgomery County, happy to be here with you this afternoon presenting SB 335. You all previously heard and passed out House Bill 315. And SB 335 has a couple of additional amendments. Just to refresh your recollection, these cross-filed bills are to address a loophole that some landlords found in the HOME Act, Housing Opportunities Made Equal. Some landlords were excluding tenants by requiring that their income, when they had vouchers, that their income was sufficient to cover the entire amount of the rent. Well, that makes no sense, because if you have a voucher, your income isn't needed to cover the entire amount of the rent. The voucher may, in fact, cover the entire amount of the rent. SB 335 clarifies that landlords who use financial information in screening may not refuse to rent to a prospective tenant with an income-based housing subsidy on the basis of income, credit score, lack of credit history, or pre-subsidy adverse credit history. So I'll just turn to the differences between the two bills, the bill that you all passed out and the bill that you have before you. So SB 335 was amended in the Senate to add two pieces. First, it clarifies that landlords may still screen for a tenant's ability to pay for the amount of rent and utilities. You all clarified that they can screen for the amount of rent, if any, for which they are responsible. The Senate added and utilities. And then second, we added a kind of a novel piece in here where landlords are to offer to their tenants the ability to send in to a credit reporting agency positive rent history payment so that that tenant can start to build good credit history. I think that's a really interesting and novel approach, and I really love it, and I hope you all will address that. Those are the two changes. I sent to you earlier today an amendment that the advocates have asked for. The advocates want an amendment that addresses potential ambiguity about the inclusion of utilities in a landlord's financial screening because a lot of times the housing authority will include utilities in that voucher. The housing advocates have asked for just some clarifying amendment language that says, notwithstanding any other provision of this section, a landlord may not evaluate whether a tenant who uses an income-based housing subsidy has sufficient income to pay utility costs if the entity that issued the housing subsidy includes an allowance for anticipated utility costs in the calculation of the tenant's portion of rent and utilities. So with that, I thank you for your time this afternoon, and I ask for a favorable report.
Thank you. We'll start with Vice Chair Charkoudian.
Hello, Senator Love. Thanks for bringing the bill. It's a great bill, and I've supported it since we first saw it. I do have a concern about the utility piece, even with, I feel like even the amendment that's been offered kind of complicates it further. And my concern is that you potentially, well, you have, like normally when there's a normal rent screening process, a landlord isn't, unless utilities are part of the rent, right? A landlord is not normally screening for, like they don't go, you know, can you pay the rent and can you pay utilities and can you pay groceries and can, like they're just, like there's one thing that they do. And I feel like the bill started pretty narrow on, okay, if your voucher is 75%, then we're gonna do a screening for 25%. And now this starts to sneak in other ways to really look at income that's very different than how you would look at it for any other tenant who doesn't have a voucher. So like that piece about having different rules for voucher holders feels like it sneaks in. So that's kind of one piece. I'll say the second piece and then if you want to respond. And the second piece is you end up with another kind of potential voucher that doesn't get counted issue, which is that if the tenant receives energy assistance, they may not have to pay energy at all. So then you could potentially have a landlord doing an energy screening, like doing a screening for an amount of money that the tenant actually doesn't have to pay out of their income because they're getting energy assistance, right? And so then you potentially need to add that in because now, you know, like we're back at where we started with the voucher. So my preference would be to take it out. I just, before we sort of work on this bill, I wanted to give you a chance to talk about that.
Thank you, Madam Vice Chair. I hear you, and all I can say is this is how it was decided that it would come out of the Judicial Proceedings Committee.
So I think I understand what that means, but I'm just trying to understand. I think I'm trying to understand some kind of an explanation for why this was particularly important, maybe? I'm trying to.
I believe that there was a concern that since utilities are not considered part of the rent, that landlords would not be able to screen for them.
Right, and they can't, right now for other tenants, I don't think they can, right? I think okay, I got it, thank you.
Thank you.
Thank you, Madam Chair. Hello, Senator Love. Good to see you.
You as well.
I just do you think that that may be because all, you know, certain utilities are attached to the property, like the water bill, and there have been many cases where tenants who leave with a big water bill. I've been left with a big water bill. And while we do have the opportunity to go to court to get it, that doesn't always pan out. So do you think that that could have been part of the reason why the Senate passed it that way?
That may be part of the discussions that I was not a part of. I can tell you, though, with the voucher holders, usually the utility is considered in the voucher determination.
Oh, so that was my other question. All of the utilities are included in the voucher?
My understanding is that when the determination is made, they include not only the amount of the rent, but average utilities as well.
And I just want to be clear, 100% of the utilities?
So that's my understanding, but the voucher does not always do 100% of.
Right.
Yeah.
Okay. All right. Thank you.
Sure.
Seeing no further questions, Senator, thank you very much for your testimony this afternoon. We'll move on to the favorable with amendments. Zachary Taylor, Matt Hill.
Madam Chair, this is Matt Hill. May my colleague in Renters United Maryland take my spot? Thank you.
I'm not used to you in this role. I'm used to seeing pets around you.
That's right. Thank you, Madam Chair. That's a newer role for me. Emily Hovermail with the Baltimore Regional Housing Partnership, also part of the Renters United Maryland Alliance. I just wanted to give brief Me Too testimony in support of what Senator Love said. We are requesting the favorable with amendments, given the amendment that she put forward. Just to emphasize what she said, the lack of specificity with the sufficient income to cover utilities creates a new loophole that could result in denying assistance tenants. What we're hoping to do here is to avoid having non-standard and different ways of evaluating the ability to pay the utilities. The good news is that because the public housing authorities by federal regulation already include a utility allowance as part of their calculations on what goes into the total monthly housing costs for a tenant. There is this existing formulas that exist. There's pages of charts of different, the different ways that they break out the utilities in response to one of the questions based on the heating, whether it's gas or electric, based on all of the different ways that you are actually supplied utilities, water, trash, everything is included, and there's a calculation that's added at the end to your rent, and that's what the assistance is based on. So because this already exists, we're hoping to just clarify, clean up this, make it so that there's not this new kind of additional layer on top of an existing process when there is a calculation of tenant ability to pay utilities. Let's go ahead and use that. Thank you.
Thank you, Madam Chair. Madam Vice Chair, Zachary Taylor, Consumer Data Industry Association. We represent the consumer reporting agencies, background check companies, and tenant screeners. Testifying today on SB 335 related to the amendments that came out of the Senate around positive rent reporting. While we do have concerns about the underlying restrictions on the use of credit history in evaluating tenancy, I want to talk specifically about those positive rent reporting requirements. Our request is that the committee amend the bill to allow for full and complete reporting of rental payments. I think our concern is best summarized as follows. If you expect to have 12 positive payments a year and someone opts out at 8 months, someone moves out and moves into a home also at 8 months, those could appear in the system as identical but not actually be the same situation. We are concerned that this will not allow reports to be as full, complete, and accurate to ensure those many Marylanders who are paying their rent on time are getting credit for that. We certainly appreciate the efforts to expand the incoming data so that consumer reports can be complete and accurate, which are used to better predict risk. And we just hope that we can work together with this committee and the sponsor to allow for full reporting and ensure that the system continues to work as it should, voluntary reporting, full reporting, to ensure fair, accurate, and complete consumer reports. Thank you very much.
Thank you. I do not see any questions for your panel. Thank you very much for your testimony this afternoon. Seeing no further witnesses, that concludes the bill hearing on Senate Bill 335. Senator Augustine has returned. Senate Bill 325.
Thank you, Chair Valderrama, Vice Chair Charcutia, and members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 325, which is substantially the same as House Bill 548 that this committee passed. I'm going to call it like, well, there's an additional provision in the House bill that indicates that it would not apply to any of the fees to set the end of the bill, any of the fees that may have been associated with a debt incurred before January 1st, 2026, which I'm perfectly good with. I'm perfectly comfortable with that amendment as it was in the House bill. We'll be happy to have the Senate bill amended as such. In the Senate, we also tried to do something to clarify earlier in the definition where we weren't as clear on the surcharge language, which was because there was a little bit of confusion on what this would apply to. Economic Matters Committee Counsel did provide really good clarifying language that I'm perfectly comfortable with also that would clean up that portion of it, and I think would really make sense and would make this a strong, even stronger bill. And so I'd ask for a favorable report on Senate Bill 325 as would be amended by this committee.
Seeing no questions, Senator Augustine, thank you very much for your testimony this afternoon. And seeing no further witnesses, that concludes the bill hearing on Senate Bill 325.
Thank you, Madam Chair.
Yep. Senator Brooks, Senate Bill 267. Welcome back to ECM, Brooksy.
Well, thank you, Chair Valderrama and Vice Chair Kagan. It certainly is a pleasure to be back to the committee where I spent the first 8 years in legislature. Yeah. And also, yeah, this is still an awesome committee. Thank you. For the record, I'm Senator Ben Brooks, representing the 10th Legislative District in Baltimore County. Thank you for the opportunity to testify in support of Senate Bill 267, that's Building Affordably in My Backyard Act, or better known as BAMBI. As amended, SB 267 is now focused on two targets: practical priorities that address key barriers in Maryland's housing market, streamlining the housing approval process, and establishing a statewide property owner registry to improve oversight of existing rental housing. First, SB 267 authorizes a streamlined approval process for residential development projects in jurisdictions that have formally identified a shortage of affordable housing. Now, this is not a mandate, but a tool. It allows local government to move projects more efficiently through their pipeline where a housing need has been clearly identified. By reducing unnecessary delays, the bill helps bring new housing online more quickly while preserving local decision-making. Second, the bill establishes a statewide registry for rental property owners. This will make it easier for state and local agencies to communicate with property owners, respond to complaints, and address housing safety concerns in a timely and effective way. Importantly, SB 267 works hand in hand with the Housing Certainty Act of 2026, while the Housing Certainty Act focuses on clearer expectations and stability within the housing system. SB 267 helps ensures we can both increase the supply of housing where it is most needed and maintain safe, well-managed housing for current residents. Together, these efforts reflect a comprehensive approach supporting new housing development while also strengthening accountability for the housing we already have. For these reasons, I respectfully request a favorable report on Senate Bill 267. And I'll entertain any questions, Madam Chair.
There are no questions for you, Senator Brooks.
Oh, well, thank you.
Thank you for your testimony, Senator Brooks. We do have two favorables here, Angelica Tupari and Michael Sanderson.
Thank you very much, Madam Chair, committee members. I'm Michael Sanderson with the Maryland Association of Counties. Been before the committee a number of times on different housing bills. Pleased to be here in clean support. The Senate has done the heavy lifting for you. This bill started with local governments gathering from our professional planners, finance folks back home. What could we do to help advance housing, or what tools do we need help from Annapolis to grant us? The Senate has pared down to 2 items. I don't think you have any opposition or any concerns about these. You've heard from the sponsor what they do. We're grateful for his leadership and for the Senate committee paring back the bill to something that should be an easy win. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, Angelica Bailey-Thupari for the Maryland Municipal League, which says me too. Thank you.
Seeing no questions, thank you very much for your testimony this afternoon. Seeing no further witnesses, that concludes the bill hearing on Senate Bill 267. Is Senator Sidnor or a representative here? How about Senator Henson or a representative? Are you here for Senator Henson? Okay, great.
But only for one of the 3 bills.
Which bill would that be, ma'am?
This will be 941.
931, okay. You mean 941?
Excuse me, yes.
Okay.
Thank you. Good afternoon, Chair, Vice Chair, and committee members. My name is Linda Hannafin Bonner. I'm representing Shanika Henson, Senator Shanika Henson, as her legislative director. And thank you for the opportunity to present Senate Bill 941, Department of Housing and Community Development, Severe Health and Safety Risk Properties, an intervention plan. We accept and support the amendments approved in House Bill 1218 and request a favorable vote of the committee for this bill to include the conforming amendments. This Senate bill directs the Housing of Community Development Office of Landlord Tenant Affairs in consultation with the Attorney General's Office to identify state-funded rental properties that pose a severe health risk and safety risks to the residents that they have under their care, and to submit an action plan identifying these risks and recommendations by August 31, 2027. The bill also requires the Office of Landlord and Tenant Affairs and the Attorney General to develop an intervention plan grounded in existing laws, ensuring that identification and remediation efforts align with current enforcement authority and hold under the judicial review. The bill does not impose penalties. Instead, it offers a range of targeted interventions proportional to the severity and persistence of the violations, such as financial consequences, corrective actions, required inspections, remediation deadlines, and, if necessary, particular actions. This graduated approach ties enforcement to documented patterns of noncompliance, safeguarding the due process. It also reinforces the role of judicial oversight by clearly framing when injunctive relief and other court remedies are appropriate. To ensure transparency, the department must submit its intervention plan and propose statutory changes by a set deadline. A sunset provision allows the General Assembly to evaluate outcomes before making fundamental changes. We respectfully urge a favorable report to provide a measured and legally sound framework for addressing these severe health and persistent failures in rental housing and strengthening the oversight in promoting proportional remedies and protecting the vulnerable residents living in these units.
Senator Henson, your legislative director did a great job. Did you want to say something? I just giving you the opportunity. You're fine? Okay. Seeing no questions, thank you very much for your testimony, and seeing no further witnesses, that concludes the bill hearing on Senate Bill 941. Senator Henson will now go to your Senate Bill 939 and then 937, whichever order you want to take them in.
Thank you, Madam Chair. Thank you, Madam Vice Chair, members of the committee. For the record, Senator Shanika Henson here to present Senate Bill 939, Real Property Bankruptcy Proceedings Exemption from Execution, Maryland Homeowners Preservation of Homestead Equity Act. This is a bill that's designed to make sure that when people fall on the hardest of times where they need to file for bankruptcy or where they're subject to garnishment of their assets and property, that they have the opportunity to preserve some of the value and the equity that's in their home. The way that the bill is structured, coming over from the House or from the Senate to the House, what it does is it allows people to preserve up to $150,000 of equity in their home as an individual. And then if they're married, it allows them to preserve up to $300,000 of equity in their residence. It also has some additional protections for people who are over the age of 65, understanding that folks who are seniors will presumably not have as much time left to build equity in their property and will presumably need that equity that's in their property, perhaps for long-term care expenses or a host of other reasons. You all did have a cross-file of this bill. The bills are not in identical posture. I believe that in the House version of the bill, you all do have a different dollar amount that's protected from the execution of judgments. And then I believe in the eligibility sections, what we did in the Senate was a little bit different in terms of the way that the relief is differentiated for people over a certain age, and then what we've done in terms of the classifications. But other than that, I would submit the bill for this committee's careful consideration. Thank you.
Seeing no questions. Oh, there is a question. Sorry. Yep. Go ahead, Delegate Ahrens.
I'm still here. So your bill is different with the amounts. You said that earlier. Is
Yes.
there any, did you have any discussions about moving to our version of that bill?
So we did, and what we did in the Senate is we took a look at the statute and kind of where it started and where it is now. So I guess we adopted the original statute in 1980, and then we looked at not having changed the exemption amount since that time. We did a kind of a baseline calculation looking at inflation. Had we kept pace with inflation over time, we would have been at about that amount of $150,000 had we continued to keep pace, and we simply did not. So what we did was we thought that the 150 that was written into the original version of the bill was an appropriate amount to have. So we considered, I think the House bill came over to the Senate at 75, if and I could look through here if necessary, but I think it came over to the Senate at 75, and we thought that amount just wasn't reflective of home values and didn't keep pace with the market over time. So we thought that the Senate version gave a little bit more reflective of where we should have been if we kept pace and what the market's doing now. We did have some discussions offline with advocates on both sides, and in those discussions offline, we did look at a number that was different than the one in the House version and in the Senate version, and there is a compromise number that's been discussed, which I'd be happy to share that with the committee as well.
Okay. When you had your discussion, are the American bankers in favor now of this or no?
So in the discussion with the bankers, there was kind of two schools of thoughts that came from the bankers. One, they wanted to be exempted from the portion that dealt with bankruptcies and to not be subject to that portion. And I think on the House bill that's in the Senate, the House sponsor was agreeable with that. And then as it related to the dollar amount, the bankers were looking at a $100,000 exemption, and they were in agreement with a $100,000 exemption. But I think if the bankers are going to be exempted from a major portion of the bill, then what we do with the exemption number, it probably bears a little bit more discussion.
Okay, thank you.
Thank you.
Okay. Seeing no further questions, that, oh, sorry, I can't see the screen over here. Go ahead, Delegate Roberts.
Thank you. So which version do you like better? This one. The Senate bill? Yes. Okay. Thank you.
Okay, now, seeing no further questions. Okay, that concludes the hearing on Senate Bill 939, and then Senate Bill 937 is next. Senator Henson again, and if you want to bring up a panel, you're welcome to do that.
Thank you. I am here to present Senate Bill 937. Again, for the record, Senator Shanika Henson. And Madam Chair, you did mention the ability to bring up a panel. I don't know if anyone signed up for it. I do know there's several
I've got
advocates
David Wheaton,
here.
Albert Turner, Zachary, no, that's unfavorable. Yes, I've got David Wheaton and Albert Turner as favorable on this bill.
Wonderful. Thank you. I think they are here to respond for questions. Senate Bill 937 is the Fair Chance in Housing Act. This is a bill that would do just that. It would give a fair opportunity for housing. The way that the bill is structured is it sets up a two-step process. The first step in that process is when a person goes to apply for housing, it would allow the housing provider to give to that person an upfront notice. And the upfront notice would give the person the opportunity to understand with detail what the criminal background screening portion of the tenant application would entail. So they would get the upfront notice and they would know before they invest their time and their resources what to expect out of that process. A portion of what they would learn in that process is that there would be some things that the landlord could screen them out for initially and could deny housing for at the outset for that tenant. So if that tenant presented to the landlord and they had in their criminal background anything to deal with child pornography, anything to deal with a murder conviction that happened in the last 10 years, anything with human trafficking in the last 10 years. If they were going for federal housing that was federally subsidized, there are some standards there that exist in the federal law that deal with the possession or manufacturing of methamphetamines. They could be screened out for that. So they would know at the outset that any of these things could get you denied for housing. What would happen after that is, though, that there are other offenses that a person may have been convicted of, and what the notice would tell them is that the landlord would then screen them for all the other metrics for a person's eligibility. So the landlord could then do the credit check, they could do the income check, they could look at that person's references, they could look and see if they had enough history on their job to be able to have the housing. So after the landlord had the initial set of offenses for which they could say you can't live in this property, they then would do the screener for all the things the landlord looks for. If a person makes it through that phase, then the landlord would do the deep dive on the criminal history. And that's when they get into the broader things that a landlord could look at. When the landlord gets to the deep dive on the criminal history, then the landlord has the ability to look at any felonies within the last 5 years. If the person has any of those felony convictions within the last 5 years, then the landlord could deny housing for that. It does give the tenant the opportunity to have the ability to petition the landlord if they have any mistakes or errors that are there, if they want to say, you know, this was not me, it's mistaken identity, or anything else as a grievance process. It would establish and set that up under the bill so that the tenant had the right to do that. But that's why it's called fair chance in housing, because what it does is it simply gets a person their foot in the door. It gives the landlord the opportunity to evaluate them on their credit worthiness, on their income, on their stability, on their job, on their references, on all those things that a tenant should be evaluated on before they do the deeper dive on the criminal history. So it does provide a fair chance for people to get housing. This body has done a great amount of work when it comes to public safety, and I think we are all seeing and benefiting from those gains in public safety. And having stable housing for people is an essential part of public safety because we understand that element of that is recidivism. And if people have stable housing to come home to, if they have some place to go and lay their head at night with dignity, then that will cut down on the instances in which people are in a cycle where they are committing offenses. And this will give them an opportunity to get off of that loop, to gain stability, and to be able to really rejoin society. So this is an essential element of that. I will mention that this bill has been worked on over time by some really thoughtful advocates, and this is the result of a lot of really great work that has gone into it. And with that, Madam Chair, I will submit it for the committee's consideration. Thank you.
Thank you. Were you all going to testify, or are you just here for questions? Just for questions. Questions, okay. Delegate Roberts.
Hello, my friend. Hello. I just had a question about what's the difference between this version of the bill and the House version of the bill?
There were a few amendments in the Senate version of the bill. The amendments start at the very beginning. One of the things that we did was we qualified the landlords a little more. So the Senate version of the bill excluded owner-occupied properties. So if the landlord lives there, they wouldn't be subject to the bill. They still would have more flexibility on the criminal screenings. We also limited to large landlords, so anybody that has 5 or more properties would be subject to the bill. We made some amendments to the offenses that would be subject to the bill in the Senate version of the bill. So we did take into consideration some of people's concerns about the composition of properties and people living in close proximity, and you'll see that incorporated in some of the offenses that are included in the bill. So that is different than what you see in the House as well. And then in addition to what we have before you in the Senate version of the bill, there are some amendments as well that are in the committee's jurisdiction now that would take the bill even one step further in terms of enforcement. We would remove from the bill, and it's in the committee's consideration to do so, the Consumer Protection Act. So we understand that the landlord community is asking that the enforcement penalty provision of this bill not include the Consumer Protection Act. And in speaking with the advocates, they've reached a compromise and they're okay with removing that from the bill. So the committee does have a set of amendments that would do that as well. So there are several material changes in how we determine which landlords are subject to the bill, how we determine which offenses are subject to screening, and then how we would enforce the bill as well.
Okay. You are so thorough. I just love you. Thank you. But I just wanted to ask about, so you mentioned in a look back of 10 years for murder. But doesn't the penalty, what's isn't there a minimum number of years? Isn't that more than 10 years?
You mean for
murder?
So it has murder in the first degree, murder in the second degree. Those things are subject to the 10 years that would precede the application date. So a person could be sentenced and their criminal sentence could be longer or shorter than that with diminution credits and the opportunity to be, back into society. There could be a number of reasons why a person could be seeking housing before or after that date. So this would only limit their ability to look at and consider the offense at the initial screening of the application before or after that date. Okay. But it could be a number of reasons why.
Okay, and then, that's 10 years after, 10 years before the application.
It's 10 years. So the way that the bill is written is that it's within the last 10 years they would be looking in that window. But as it relates to the offense, it's 10 years from the sentencing.
Okay. All right. Gotcha.
Thank you.
Thank you.
Okay, Delegate Adams.
So I'm trying to catch up here. So there is another bill. It's the same bill. This is not a cross file. So we're kind of just looking at this through the lens of what's coming over. I remember the other bill. The penalty provision, it seems like it's a $500 civil penalty per violation. And there seems like, all right, so we're moving the enforcement from where it was in the other bill, Consumer Protection Act, to the Office of Tenant and Landlord. And so my question is, somewhere on page 11 of the bill, it does say that the Office of Tenant and Landlord Affairs may not publish any identifying information about a landlord that is subject to the complaint if the landlord is in good faith compliance with requirements of the subtitle. So I'm trying to read in the bill what happens here, but are they posting, under this bill, are they posting public notice of landlords that violate this provision? No, they are. Okay, so it's on page 11.
So thank you for your question. Two things with that provision.
Sure.
One, the $500 cap on civil penalties that you mentioned, I want to commend the advocates on the bill. That was a great, great concession that they made. There were some people that were of the mind that for some of the large landlords, $500 would be such an insignificant slap on the wrist that they didn't know if it would be worth, the price of admission in terms of compliance. But the advocates did did come to the table and they did compromise. And I'll give that same kudos to the realtors and to the landlords as well, because that number was reached on compromise on both sides.
Well, I was the guy that was in the committee over here complaining about the Consumer Protection Act, so I appreciate the change.
Yes.
What
May I address the second part, Delegate?
Yes, please.
As it relates to the publishing and the list, that portion as well, we do not have an amendment before you on that, but as I speak to the advocates on it, I believe in a conversation with the Speaker's office that it would all but eliminate the fiscal note by removing the reporting requirement, and the advocates are in agreement with removing the reporting requirement because I believe all of the dollars in the fiscal note are attached with the mechanics of reporting the landlords that had been in violation of the bill. So if there was an amendment that did that, it would be considered friendly by myself.
All right, so I was spending most of my time on the penalty side, so I think you've answered all my questions on that side, and thank you.
Thank you, sir.
Delegate Queen.
Thank you. Thank you, sponsor, for the well-thoughtful bill. I just want to kind of understand the posture we're working with now. So you mentioned, and I noticed it's passed out of the Senate without any issue, I believe.
That's correct.
But you've mentioned that there are 2 amendments that we now have here about the consumer protection part and the $500 cap for civil penalties. Am I to assume the Senate did not take those up?
The $500 is included in the third reader version from the Senate, but the Consumer Protection Act, that language was preserved in the Senate version of the bill, but it would, we are open to an amendment that would remove that from the version that this committee would hopefully pass out of the House.
So then it would be in line with what the Senate passes, what you're saying?
No, Delegate, the Senate did allow for the Consumer Protection article to remain referenced, but it would, we would remove those references on the House side.
So I guess that's one question I'll have about, you know, will the Senate, does the Senate agree with this? Are we going to pass something that goes back over and say this is not what we wanted? I mean,
myself and the advocates, we did have that conversation with the Senate, and it would make the bill in an even lesser posture than it left the Senate. And so it would be even easier to pass in the Senate because it would be taking the protections that were given to tenants with the criminal history, and it would be lessening them. So for the Senate, it would be even easier to move once it came back in that posture.
okay, which they already moved already, but okay.
That's correct.
That's fine. And then the other part, you're saying that there's a third possible amendment that you're considering to remove the reporting part to make the fiscal note go away.
That's correct.
That's also was not discussed. Was that discussed with the Senate, and what will be what do you believe will be their response to that?
The same as well. The Senate was comfortable with the fiscal note and did pass it with that intact, but in speaking with the Speaker's office here, it would gain additional support on this in this chamber if that were removed and the reporting requirement were not there. So in speaking with the Senate, if it came back in that posture, again, it would provide even lesser protections for tenants who have a criminal history. But for the purposes of moving it through the other chamber, it would make it even easier to do because the
fiscal note I get, but I guess maybe I should ask, what do the advocates think about removing the reporting part?
They are here. They can certainly respond.
Yes, we to get this bill across, you know, we want to ensure that if there is a problem with the fiscal note and the reporting requirements were the kind of the large brevity part of that fiscal note, we would be willing to take that out so that it would pass this chamber.
Yeah. I understand. Thank you.
Thank you. Delegate Pippy.
Thank you, Madam Chair and Senator, good to see you. So a couple of things you addressed, the fiscal note, the consumer protection violations. So one question that I have is for the distribution of methamphetamine, why only that drug? So like, for example, if somebody was, I don't know, manufacturing cocaine or heroin, or, I mean, are those not issues that, I'll let you respond. I'm sure you thought about that.
Delegate Pippy, so my name is John Bam with the Vera Institute of Justice, and I can answer that question. So federal law has it that public housing authorities cannot deny, well, it can't, but are statutorily required to deny people that are convicted of producing methamphetamines in federally subsidized housing.
Sure.
So that clause or that provision in that law speaks to that federal law.
So would it be fair to say that if that wasn't a federal rule, that there'd be no prohibitions against preventing someone who's a kingpin drug dealer moving into a community?
I'll answer that. Yes.
Perfect. Great answer. The next question that I have is there's a bracket on the reprint. Looks like page 3, line 17. We bracketed 7 and added 3. So what are we doing there? Trying to read and talk and put it all together. I apologize, I was presenting a bill in the Senate, so.
Page 3, line 17, and where it says subject to Title 2A of this title.
Yep.
That language is just referencing and qualifying the additional language that surrounds the look-back period. So that's the existing part of the code. There already is language surrounding how a person's criminal history can be referenced in fair housing. So that's the existing part of the code. So it's taking the existing part of the code and saying, yes, we're not striking the existing law. We're only saying the existing law is now subject to the new law.
Okay, so in layman's terms, that means you can only look back 3 years, you can't look back 7 years?
So what this is referencing is the reusable screening, is that part of the existing code. So it's saying that the person's reusable screening can be used for that period of time.
Okay, so that's not related to the look back at all, it's just that, okay.
It's just how long you hang on to it. It's the shelf life.
Okay, and then the last question, and I'll just answer it. How do we determine which crimes are acceptable for someone to move into a community and which ones are not?
I'll say that the process of this group, it took a lot of really thoughtful consideration of people who have returned home, as people who have come home from incarceration, speaking with people who obviously live in community, with people who have returned home from incarceration and people who do not, to figure out. And then also they did a lot of really scholarly research to look at the data that surrounds people who've returned home from incarceration, to look at what sorts of offenses people did reoffend on. And that's why you see some of those offenses, like offenses against children, like some of those sexual assault offenses, all of them, where those sort of offenses can be screened out at the outset, where landlords can deny housing for those reasons. That's why you also see removed from the bill landlords who are owner-occupied, landlords who are some of those smaller landlords, where you just don't have the sophistication to maybe build in some of those other security features or other elements into your community. So I do think it was a lot of thoughtful consideration of the real stories of people, but then also layering that with the data that supports how do you build a safe community.
And if my final bite, and I apologize, I was going to ask this earlier, but I forgot. So page, I'd like to be specific. So page 3 of the reprint, and this is line 31, is a section about in whole or in part, directly, indirectly. Is it fair to say that a landlord, when doing a background check, or like for references, for example, could a landlord be caught up in this? And I realize the fine has been lowered down and all that, but when you get references, I don't know. I mean, old school way of, a job interview or an application for a rental, sometimes you get references. Could a landlord get in trouble if they indirectly or directly or whole or in part get some information on a tenant that, for example, if they reach out for a reference and then the previous landlord is like, well, that person did this, this, and that, would that subject the landlord to a violation of this
That is
law?
Trying to clarify the small landlord exemption. So the in whole or in part references the landlord's ownership of the property there, not necessarily the way that the landlord comes upon the information about the person's criminal history.
Okay, is there another part of the bill that would address that? Because I know in the other bill that we had presented to us, that was part of their bill, and I'm just quickly skimming here, but.
No, it gives them, the bill prescribes the notice that would be given to the tenant, and then it prescribes when the landlord could use that information to deny housing. But it does not, and John, correct me, it does not prescribe how the landlord could come upon that information otherwise.
Okay, all right, thank you.
Thank you.
More bites at the apple. There's not going to be an apple left. Delegate Roberts.
Thank you, Madam Chair. There were just two more questions I had because, so it seems like every housing bill that comes through the House, they consider a small landlord anyone who has 6 or more. Would you be open to raising that to 6 or more?
So we tried to keep this on par with other language. We actually had that conversation in the Senate as well, trying to make sure there was parity. The 5 or more comes from our fair housing law. It's also consistent with federal law as well. If there are references that you see in the code that say 6 or more, we certainly would want to see that and review it and certainly would be open to it. But the 5 or more was landed on because that's what we consistently saw in other references in the code, and we wanted to try to have that parity.
Okay, and then the last question was, with regard to any criminal history checks, are these only for crimes that were committed in Maryland or nationwide?
So the criminal, we had that conversation too. Because it prohibits the landlord from using certain information, we didn't want to put on the landlords, especially the less sophisticated ones, and I don't mean that pejoratively, I mean that in terms of resources and manpower. We didn't want to put on them the responsibilities to interpret what's a felony in another state versus a felony in Maryland. We understand that, for instance, it's a felony to complete an abortion at a certain term of gestation in, for instance, the state of Texas. And so we didn't want to say if you commit that felony, that then that means felony under this bill, and then that means that a person would be excluded from housing in the state of Maryland. So it does write for the specific codes of the state of Maryland, and we didn't want to put on landlords the burden of trying to interpret the laws or the criminal histories or the backgrounds of other states. We can provide assistance here in the state of Maryland with that and our codes with clarity, but we didn't want to put that on the landlords to do that for all 50 states.
But do they have the option if they want to?
Not under this bill.
Not under the bill?
No.
Because we know, I mean, like in Maryland, it's legal to have an abortion, so we know that that would not be a qualifying reason.
There are things where the lines are not as bright. We have done a lot in our criminal code here in the state of Maryland to make sure that our codes express our values here in the state of Maryland. I know that there are bills, I think that the committee this morning downstairs was voting on just this morning about the way that we will charge certain people of certain ages and the different things that we will do. And our codes are dynamic and they are always changing. Every session we come here and there are things that were felonies, you know, before the 90 days that are not felonies after the 90 days. And I think all of the 50 states are always doing that. And so what we didn't want to do was overburden our landlords with trying to keep pace with the laws of each of the 50 states. And every time their General Assembly goes in, what's out. We did have the conversation surrounding in the Senate side an amendment that would have addressed that in some ways, but in trying to figure that out, what we came down on the side of and choosing to pass the bill without it is that we didn't want to set our landlords up for a situation where there was even the presumption that there should be doing a 50-state survey to figure out what people's background checks were like. Landlords, when they get a background check, they typically are doing some sort of commercial software. They're not going into the FBI background system and doing a fingerprinted NICS background check like you would if you were doing a child care center or some sort of sophisticated, you know, background check for criminal background purposes. You're using internet software. And so we didn't want our landlords to even have the presumption that they were going to be able to interpret the laws of different states or have access to accurate records of different states.
And, okay, but crimes like murder, sex crimes, those kinds of things, those are not, they don't need to be interpreted.
We did discuss this on the Senate side, and now the bill is in the jurisdiction of the House, so the House will have the ability to have these conversations again, and maybe the House will come to the same conclusion that the Senate did. Maybe the House will think it's a simpler conversation about what's a bright line, what's in, what's out. In the Senate, we had this conversation in earnest, and we came to the conclusion that it is not always a bright line. There are certain defenses that are available to people in the law for certain offenses that are not in certain states. Murder is not always just murder, but we understand things like felony murder, which means that a person could not have been the actor in a murder, but they could have been in proximity to a murder, and now they could have a conviction of murder. We understand that there are laws and rules surrounding people being exonerated later on when certain evidence comes into place, and there are states that give people more opportunities to present those things, and there are places where people don't have opportunities in abundance to present those things. So we didn't want to impress upon the citizens of Maryland the values of other states. So when we had those conversations and tried to figure out how can we interpret the values of all 50 states and ask an individual landlord to do that because they own 7 properties, we just couldn't find a way to neatly make that fit.
Okay, thank you.
Thank you.
Delegate Adams.
Let me just say this, and I want to start by saying that Delegate Ampry and I have talked about this bill in the House, and I've supported bills in the past that are like predetermination review of criminal background when it comes to licensing. So I think I understand and respect the principle of, people once they've served their time should have the right to live their life, and housing is tops along with, no, it's the tops. You have to have shelter, right? So it's important. So without getting into a heavy debate on the subject, because I know landlords that take risks, they don't need this bill to look at someone and make a decision and say, we're going to try this thing out. There is a bill, okay, in the House called good cause eviction. And so if you've got a good landlord that's going to take this review and they're going to say, look, we're going to give you a shot, okay? We're going to do this thing. And then 6 months down the road, because this is going to be a risky decision no matter what, riskier because of the person's background, and something goes wrong. If we pass this bill at the same year we pass good cause eviction, which is going to make it very difficult for a landlord to remove a tenant, and I don't want to get into a heavy topic discussion on this, but I feel like these 2 bills married together make it very hard for a landlord to have a workable business model, which is to try to be fair, try to be equitable, give people a chance. It's not always going to work out. And if it doesn't work out, and you have the backup of the good cause eviction, which means very hard to have a landlord then have that person removed from the property, that I think we've got an unworkable situation. Do you have any thoughts on that subject? And if you do, great. If you don't, maybe just take thoughts that I'm giving you that as a person that understands landlord-tenant, these are the things I'm thinking about.
I appreciate your expertise and the thoughtfulness of it and the work that you've done as it relates to professional licenses and making sure that a person's background isn't always determinative of their future, especially if they have invested into the skills that it takes to build a profession. I will say one of the distinctions there and with this is that in the professional licensing, they often are subject to fingerprinting, which does give a more comprehensive background, and our landlords, that's typically not the sort of background that they're getting. But as you look at the landscape of good cause and fair chance in housing, I'll only say that with fair chance in housing, the person that would be impacted by this bill is a person that's done a significant amount of work on themselves and their life. Because they're a person that committed a criminal offense, and then when they present it to a landlord, to even be considered under this bill, you have to be credit worthy. You have to have sufficient income. So you have to make 3 times the monthly rent. In the state of Maryland, monthly rents can average, I know in my district here in Annapolis, the average rent is $2,500 a month. So you have to make $2,500 a month times 3. You have to then also have been on your job for long enough. Your references have to check out. You have to have a credit worthiness that's to the landlord's satisfaction. So you have to do all of those things after having had a criminal record, and then you present yourself worthy in those ways. So no one's going to get anything under this bill that they haven't worked very, very hard for.
I'm going to leave it like this. I just think it's a tough subject to say this bill is important and let's pass it, because I think I understand some of the components of this.
Yeah.
I'm saying that at some point, a good landlord can make a bad decision. And those bad decisions, there has to be recourse. There has to be the ability to, for the safety of the property, for the safety of their tenants, for their own housing, if it gets destroyed. I'm just saying that there are examples, and
Isn't
There are
that
bills and there's going to be, there's so tomorrow. The point is that in this bill, you're looking for support. And I'm saying it's hard to have that conversation when there's not the other side, which is the landlord needs to be able to run a business. That's all I'm saying.
Okay, thank you. Seeing no further questions, I'll just mention that you all may or may not have picked up the good cause, which is the other part of the question, but that bill does allow for any eviction, good cause related to any sort of criminal activity, even minor misdemeanor stuff that doesn't touch the kind of things that are in here. Okay, that concludes, no, we have one unfavorable. Is Zachary Taylor here?
And Madam Chair, I apologize. I know it is the custom to remain through the unfavorables. Is it okay with the committee if I go down to judiciary for a bill hearing? I believe they are holding the committee.
Yeah, I understand people are running up and down these stairs, so go like the wind.
Thank you.
Thank you, Madam Vice Chair, members of the committee. Zachary Taylor with the Consumer Data Industry Association here again, testifying, requesting some amendments to Senate Bill 937. We are seeking the removal of the changes to 8-218B21 that limit the contents of consumer reports. Consumer reports are regulated at the federal level by the Federal Fair Credit Reporting Act. Reusable tenant screening reports are a type of consumer report. It dictates the obsolescence period for which convictions and other criminal record history can be included in a report that is at least 7 years in the case of adverse information, or convictions can remain on a report indefinitely. These provisions conflict with that and are preempted by the FCRA. Some of the conversation around the contents of consumer reports, the look back periods at different parts of this bill do seem to conflict with one another in terms of 10 years versus 5 years versus 3 years. Our preference would be that Maryland state law adhere to the Federal Fair Credit Reporting Act, and that these changes to this particular provision as part of this bill be removed. I'll leave it there. Thank you very much.
Thank you. Seeing no, what, is that a question? Yes, Delegate Roberts.
So are you favorable with amendments or opposed?
Sorry, Delegate. We are favorable with opposed, or favorable with amendments.
Oh, okay.
We signed up the wrong way. That's my mistake. I apologize
okay.
for the confusion of the committee.
Thank you, thank you.
Okay. Now I think, seeing no questions, that concludes the hearing on Senate Bill 937, and I think I saw Senator Sidnor show up, so let's move back to Senate Bill 274.
Good afternoon. And thank you for your patience. I was at chairing the joint ethics meeting, so my apologies. Senate Bill 274 is the cross file of House Bill 573 that you had all passed. Just to give and ensure that we're saving a lot of time. The distinction now between the bills is we had amended it in the House to delete some language regarding intent, and we had put in and included new language, or uncodified language, kind of pointing to the court as to how, what our intent was, pointing to not only the Supreme Court case of inclusive communities, but also to the Federal Register and the Code of Federal Regulations, as well as a state's Supreme Court decision, Hare versus David S. Brown. I could go into a little bit of what the bill does, but as you all know, this bill stems from a bill that you all again passed even last year with Delegate Tavares, who was trying to codify and make certain that we did not lose the ability to deal with disparate impact. So I will rest so as not to waste any of your time and leave it at that.
Thank you. He can't help himself. Delegate Adams. Delegate Adams.
I just have to stop for a minute, and it's going to be a quick question, and you probably answered it as you were testifying. So the bill in the House was the regardless of intent. You're striking that under, or well, the Senate is striking.
The Senate struck that, correct.
Okay. And if I remember correctly, the complaint goes to the Civil Rights Commission.
Which complaint?
Okay. How about if I just,
think there's a phone a
we'll
friend.
take it offline. I need to read the bill.
Sure.
It was a big bill in the House, and I see you've changed an important component to it. I need to just stop it.
Sure.
Delegate Ampry.
Thank you, Senator. Always good to see you. Just a quick question. So with the changes you all made, I know that the purpose of this bill, going to the intent of why we brought this bill forward, was to make sure that we're safeguarding residents of Maryland from possible changes to federal law under the current administration.
Yes, sir.
And just want to understand, with these changes that you've made, does that still fall directly in line with the current federal guidance, or is this changing it in some kind of way?
No, it falls in line, but I will say that the advocates are certainly wishing that this bill looked more like the bill that you all passed here in the House. So if I just
So it sounds like you're happy to see the House get a good look at it.
I have no problem with that.
Okay, all right.
Thank you. Seeing no further questions.
Thank you very much.
That concludes the hearing on Senate Bill 274. And colleagues, that concludes our hearings for the day. Have a good evening.